registry wills made by a deceased person, which may be in possession of another. Because when you fail to deposit such a will, it may attract a civil or criminal action against such person. Now, both are High Court rules and the administration and succession estates of deceased persons of laws of Anambra State made the provision for probate and administration involving foreigners as well. It covers persons who are not even indigents of such states. I'll quickly highlight some of the duties the probate registry does. But then it's always important for us to know that before you can access probate, you must show your locus. That is, you must show that you are an interested party or you should fall under the priority list. Priority list we regard as persons who are of beneficial interest to the deceased person. Now, in our priority list, other priority list, applicants for letters of administration, we can find it flows from either the surviving husband or wife of the deceased, as the case may be, the children of the deceased, or the surviving issue of a child who died in the lifetime of the deceased. Then the father or mother of the deceased, then the brothers, the sisters of whole blood. We also have brother or sister of half blood, the grandfather or grandmother of the deceased, the uncles, the aunts of whole blood, or issue of any uncle or aunt who died during the lifetime of the deceased. Also, a creditor can apply, and then the administrator general. Now, we should also note that the purpose for which probate is granted and letters of administration is to enable the beneficiaries of the deceased have access to either the death benefits or pension of the deceased, and also to have legal title to landed property, or to enable the beneficiaries access and distribute or apportion the deceased estate to his or her loved ones. Now, in applying for letters of administration, the first thing you should come up to the probate registry is a death certificate. Now, when you produce the death certificate, you'll be issued with a bank certificate. But prior to that, there is something we run at the registry, which we call search. We run a search to see if anybody had embarked on such application in the past. Now, where there is no application existing, then you are issued with a bank certificate. You go to the bank where the deceased had an account. The bank will enter the name of the deceased, the amount left, the balance of the account in the bank certificate, and then you return to the registry. Upon return to the registry, you have some fees to pay, which we call pre-fee of some certain amount of money. And then other documents which you also have to provide are affidavit. You have to swear to an affidavit of no previous application, because it's been known that most people would apply for for letters of administration probably in Anambra State, and then they go elsewhere, maybe go to Jigawa and make the same application, which is wrong. It's not proper. You're only entitled to one letter of administration, and then you can run further certificates like further security, as the case may be. Now, other documents that you need to supply the probate registry, depending on the situation that presents itself. If there's a minor to the deceased, then you probably have to get a next friend to the minor. You will depose an affidavit stating that you be of good behavior and you will not meddle with the estate of the deceased, and you help to check, act as a check on the part of the minor. Then you also produce a letter of identification from your communal leader of the deceased, showing that they know your relationship with the deceased person. And then you also have the Gazette, which we published at the government press. There will be a 21 days legal notice from the local government of the deceased as well. And then you also have consent letters to be sent in, assuming you have sisters or brothers who want to give consent that they are aware that such an application is before the probate registry. Then you also have the renunciation forms. Yes, I can hear you.
Yes, Your Honor. Well, because of time, could you tell us the durations?
Okay.
So expected duration, all things being equal, for application for LOP.
Okay.
Yes.
So I'll be specific. In Anambra State, where I work, for you to obtain the letters of administration, having confirmed with all the payments and you follow it diligently, between 1 to 3 months, you will have your letters of administration ready. And then that of probate, you should have it in about 2 months. It's ready. But the only thing is that for you to apply, it's faster. It's easier for you to procure your grant of probate than that of the letters of administration, because of a lot of documents and a lot of time measure you have to comply with. But that of probate is much easier, unlike that of the letters of administration.
Yes, Your Honor. Thank you. And how often do you read wills?
Oh, we read will weekly on a particular day. Depending on the number of wills we have, we read them. We invite the supposed beneficiaries. They come in, we run an assessment on them. We take what you call a checklist to be sure they're all present. And then we go ahead and then unseal the will for reading.
Yes, thank you. So we will return to you shortly for further explanations.
Okay.
Now, Adetola. Yes, Adetola, I hope you can hear me.
Good afternoon, Peter.
Yes, good afternoon. Thank you. So in Lagos, we understandably we may have different practices in different jurisdictions across the states in Nigeria. But it is good that we are looking at Lagos and then Anambra states. And again, you can bring in experience gained from your practices across the other states in Nigeria. But again, what are the key issues in ease of doing business in probate administration?
Okay.
What would you consider to be the key issues?
Yeah, thank you for that. Thank you to the Honorable Mrs. Ukamaka. I heard everything you said, and I would just like to point out that the difference is more or less like the same procedure in Lagos State, but that the difference might be in respect of detached wills, because in Lagos State, we have something that is called a detached will, a will that is found at home or that was not lodged in the court before the deceased person died. So in Lagos State, they allow people lodge detached wills. So if a will was found maybe in the safe of the dead person or somewhere outside the jurisdiction of the court, it can be brought to the court to be lodged as a detached will. I just wanted to add that, to the Honorable Mrs. Presentation as a distinction of what we have in Lagos and what they have in Anambra. So apart from that, it's more or less the same thing. So with respect to the ease of doing business, can you hear me well? Are you following well? Just to be sure that I'm not ranting here. Okay.
Yes, we can.
Okay, fantastic. So with respect to the ease of doing business in Lagos State, ease of doing business generally is how easy it is to conduct probate business at the probate registry in Lagos. But for us to consider that, I would like us to also take consideration of where we are coming from. What was the situation before now, and what is the situation now, and what are the differences? Which one is better, which one is worse? So prior to now, You go to the courts, you want to apply for letters of administration, for example, you write your application letter, you submit it at the registry, they ask you to depose to an affidavit that you have never applied for letters of administration before in respect of that estate. You depose to it, you also conduct their search to be sure that nobody has applied in respect of that estate. After that, they will issue you the application forms, which consist of the bank certificate, the application for letters of administration, oath for administration, administration bond, declaration as to next of kin form, the inventory of assets form, the particulars of freehold or leasehold properties left by the deceased, and the schedule of deaths and funeral expenses. You take these forms away, you start with the bank certificate, you go from bank to bank for them to endorse how much the deceased had in his accounts. After the banks, you go to the registrars because you need to be sure of the portfolio that the deceased person had. I mean, you want to gather all the assets to be sure that you are putting the right information to the probate registry. So after you've done this, you also provide a list of all the assets that the deceased person had before he passed away. And then you go back to the registry after the administrators appointed by the family to represent the estate have signed the forms. So you take the physical forms back to the estate and back to the probate registry, and then they take an account of what you have submitted in respect of liquid and real assets, and they do a calculation of how much you should pay. You go to the bank, you make this payment, you come back, they issue you with a receipt, and then they go to the publication stage, which is where the estate is published in the national daily newspaper for anybody outside that has an opposition to the grant to come forward and oppose the grant. In the absence of any opposition within 21 days, the minutes of an order is drawn up and taken to the probate judge. The probate judge signs and okays the minutes and order, and then orders that the final grant should be drawn up. The final grant or letter of administration is drawn up, and then the administrators are invited for maybe an interview with the administrators and also the surety, where the value of the assets submitted exceeds 1 million naira. Then when this interview is done, they issue them with the letter of administration and everybody goes their separate ways. But now, the same thing more or less applies to grant of probate, but the difference is that the deceased person has lodged a will, the will has been read, and then you now go on to apply for CCCs of the will and also grant of probate. Of course, in the grant of probate process, there is no publication. So what you have instead is a marking of the will. So here, the executors are invited to come and mark the will. And what this means is that they come forward and say, oh, everything that this deceased person has said in this will, we are going to ensure that we comply with it. All the beneficiaries that have been named will get whatever they have been, we have been instructed to give them by the deceased person. So after this, the grant is also drawn up, sent to the minutes and order for the grant is drawn up, sent to the probate judge, who will okay it, and then the grant of probate will be drawn up. So that was then. So what's the difference between then and now? Now, we have what we call the Lagos Automated Probate Registry System, which is an application that the probate registry has designed to ensure that all applications for letters of administration, grants of probate, resealing are done online. But how does it work? You open the portal, you click on their link, you go to the website, you register as a new user, and then they will provide you with login details. With these login details, you can now go back to the portal to access the services that the probate registry has to offer. So, for example, if you want to apply for letters of administration, you click on letters of administration. All these forms that I mentioned before have been uploaded. So instead of having the hard copy, you now have an e-copy that you still fill with the same information. You provide the same passport photographs, you attach it to your application, means of identification for the administrators, you attach it to your to the forms online, and death certificate, application letter, all these things will access. After you finish typing all the necessary information, you populate the forms with the necessary information. At the end of it, it will tell you that you now have to go to the registry to collect your bank certificate, because they're not going to give you an e-bank certificate since you still need to take it to the registrars and the banks. So you take all these documents that you have uploaded online, you still need to take it to the registry. And when you get to the registry, when they open their own portal to view what you have put into the system, they might help you print out, or they will ask you to print out a hard copy of the application form that you have filled online. So with this, you will get your bank certificate. You still need to take the bank certificate to the banks and the registrars, and then also populate the bank certificate with whatever necessary information. Then after that, you go back with the bank certificate, and they now move your file to valuation. But of course, in the electronic filling of the form, you would have written the assets that you want to obtain letters of administration in respect of. So the file will be moved to valuation. Valuation will come up with their own assessment. If necessary, they'll say, oh, you need to take us for an inspection. We need to see the property that you have declared for us to be able to come up with a reasonable value of how much you will pay as estate fee. So after this has been done, you pay your fee. The procedure is more or less the same as the previous, how it used to be, which is as if you were filling a hard copied application. So the only difference now is that you initiate the application online, but the procedure is still more or less the same thing. That means the file will still move from, there's still a physical file that will move from table to table for the process to be complete. So we now want to know, ease of doing business. Where are we coming from and where are we now? Are things easier or are things more difficult? A lot of people have, complained, a lot of people, well, I won't say a lot of people, a number of people are still not very electronic savvy or technologically savvy, and they will still prefer to do things the old way. And then even those of us that we think we are technologically savvy, we still have difficulties at the probate registry. For example, the other day I filled an application for resealing online. I initiated an application for resealing online, and I went to the probate registry, and then it was time for us to go for an inspection of the property. So for example, let me just give you a wild example. I wrote number 5, Tola Close, Lagos, Nigeria. When I got to valuation, they said, no, that you cannot write this type of address. You have to be specific as to the location of the property. Is the property in Ikeja? Is it in Lekki? Is it in Lagos Island? Where exactly is the property? Okay, sorry, madam, the property is in Ikeja. They said, okay, so that means that you now have to go back to ensure that the change is registered into the system, and you cannot cancel and just write that the property is in Ikeja. So I myself, I faced that difficulty. So now, instead of something that you would have easily done by canceling or just changing an error on the face of the form when we used to submit physical copies, now that we have to fill the application online, you have to go back to whoever is in charge to help you remedy that error. So of course, that took another 2 or 3 weeks. But apart from that, let me talk about the good sides of the digitalization process. The digitalization process meaning that we cannot submit applications online. I noticed that there are more departments and there are a lot of new staff now at the probate registries, and all of them have their various departments. Everything is more compartmentalized as opposed to the way it used to be before. Before, if you take your form there and you submit it, one person will be the one that will handle the file from the beginning to the end, and you have to keep going back to that person. Oh, do you have any updates for me? Where is my LA? Where is my grant of probate? And then you'll keep telling you, okay, this is what is going on. But with this process of the Lagos Automated Probate Registry System, you know at every point in time where your file is. So if your file has gone from valuation, it has gone back to the registry, you know where to pick up your assessments. There is a department for that. The people that are assessing, they are called the assessors. They will calculate how much you are supposed to pay at probate dues and give you your assessment. You go to the bank, you make your payments, you bring back the receipt to them. They know what to do. After you submit it to them, your file moves to the next stage. Minutes and order, and another department is in charge of that. So everything is more compartmentalized. Every department has a role to play, and it's not just one person that is handling your file from the beginning to the end now. And then, of course, faster service delivery. The effect of this is that it leads to faster service delivery, and then there's more information. People actually know what they are doing at the probate registry now. You have access to information. But although they say it's a digitalized system, I find that it's only the beginning that is digitalized, that you have to fill your application online. Every other thing is moving from table to table. So it's more or less like the whole thing all over again, apart from the initial filling of the form online. So we still have to ask ourselves, is it really digitalized? Has the purpose of digitalization not been defeated by this having to move from table to table? Then I also noticed that they say it's digitalized, but if you want to apply for a CCC, you still have. Yeah, sorry. Yeah, I can hear you. You're saying something, Osisa.
Yes, okay. So I wanted you to hold on to your thoughts there because you have actually struck a chord. Now,
okay.
So to manage our time very well, we would want you to, in question 4, which you will address, you have the opportunity to speak more on this. We would want you to specifically talk about in ease of doing business, in digitalization, can we include query? So for instance, the experience you had, you could have been queried electronically, and then that enables you to answer the query prior to walking into the registry. Again, because again, this is given Honorable Ukamaka's presence here. Lagos is a state of example, really, I mean, without apology to all other states. It's a key leader in across all the markets. Now, how far can we go with endorsement? Endorsement, I mean, I submit a form, can I electronically, could it electronically send to perhaps registry of companies to endorse the number of shares the deceased has? Could it be electronically emailed to the banks to endorse on the form the monies in the account? So, and then again to pension, to any other assets. So these are some of the things we want you to highlight in question 4.
Okay.
Among all the other things you have in mind on how to improve on ease of doing business. Yes. So for now, may we return to Honorable Kamaka. So Your Honor.
Yes, I'm here.
So Your Honor, there are questions. Yes. Okay. So some persons hold the view that to deepen innovation, because we acknowledge that every state in Nigeria is improving on the quality of service.
Yes.
I mean, in accordance with their capabilities. So, yes. And some persons hold the view that laws may need to be amended or new legislations. So, would you think that to deepen innovation and more user-friendly probate administration, that it will just be limited to matters of policies and not new legislation or amendment?
Okay, thank you. Before I go over to your question, I'd like to correct an observation Ms. Anyaro made with regards to the area where she mentioned that any will, is it default will or something, but I rightly mentioned that Order 59, Rule 15 of High Court rules also entertains wills found or may be in possession of another to be brought to the registry for deposition. Thank you. Now, going to your question, if by legislative review, you mean the process of lawmaking, yes. And Section 72 of our High Court Rules of Anambra State permits the High Court Rules Committee, with the approval of the governor, to make regulations with respect to certain things. And one of the items is especially in sub-rule 1G, talks about the procedure of the grant of probate and letters of administration, and for securing the due administration of estates, including the fees to be paid and the amount and the time of payment of the same. So the issue of making something more innovative or more user-friendly has to do with procedure. So the High Court Rules Committee, to that extent, has the right to make amendments on the available rules. Already, the High Court Rules is made by the High Court Rules Committee, and there are certain orders here giving regulations as to how to deal with probate and administration. So such rules can be amended to include some innovations and user-friendly procedures. This can be made by legislative review instead of going all the way to the House and know how this works, except it's something that is of substantive review, then we may need to approach the House. So a High Court Rules Committee is permitted to do that by Section 72 of the High Court laws. Even the Chief Judge has the powers to review such rules. Now, it would certainly be a welcome development if some innovations are considered. We may look at the area of how to determine or calculate the value of shares, just like you mentioned earlier. Now, we know that one of the bases of the probate registry is to generate revenue for the government and to guard against revenues by which tax has been evaded and maybe they've been avoided over the years. Granted that we include shares when dealing with estate of a deceased, but it can be difficult to know how you stand on capital gains tax, which is calculated value to be paid. Now, when it comes to shares, for instance, it can be somewhat confusing. So there's a need for there to be a review on how shares should be calculated, how it should be valued. I will propose there to be an interface, maybe with the stock exchange, so that probably all of us can also cash into this electronic system of probate registry, just like what the Lagos State probate registry has tried to adopt, which I will call a partial kind of e-probate. But then there is need for there to be a review on how shares should be valued. Just like in England, there are two ways they consider how shares should be valued, like whether the shares were sold during probate or whether the value of the share rose since the death of the deceased. I'll give you another example on personal chattel, where there are artworks, jewelry, ornaments, wristwatches, these things are of great value, which should attract tax as well, be it 10% or whatever. There's no specified rule that states the above mentioned should, or how it should be valued. So the worth of all these items should be valued. It's not enough to just lump the entire personal chattel and just give it a particular percentage, no. And I also want to suggest that as part of the innovation, I see that there should be a special department for professionals who are specialized in identifying artworks, jewelry, ornaments of great value, wristwatches, fabrics, so that we don't continue to lose revenue. And upon doing this, I feel that would help us build our rules and forge ahead with our time as well. But then in Nigeria, I do not know how far we'll go with this, because all these things, possibly they need a data system. You need a functional data system for you to assess all these things. So calculating shares in Nigeria is just simply done across board, be it private company shares or public quoted shares. There ought to be an innovative way of arriving at how shares should be valued and at what percentage. Also, another innovation that may be welcome is the need to have a probate jurisdiction of the High Court, where the probate matters probably which emanate with various issues can be resolved. Well, I feel there's a need to build our precedents with regards to probate rules. Thank you. Hello, Mr. Sit, are you there? Mr. Sit, are you there?
Unmute yourself, Osita.
Yes, I'm muted. I'm muted. I've unmuted myself. Yes, thank you. Okay, thank you. So again, in attempting to answer question 4, we have to make contributions as to, make further contributions. Yeah. So, but again, we're all here because we are committed to making the probate registry more user-friendly and innovative, and so more economically viable for all stakeholders. So because if I can save time from going shopping from one bank to the other in order to get more cash in bank, the value of cash in bank, again, it makes it more economically viable for me as a practitioner, and saves time, which saves time and for the client. So how do you think we can make probate registry more economically viable for all stakeholders? Thank you.
Yes, so I think first of all, we need to understand who the stakeholders are. Of course, the government is a stakeholder because the government has the monopoly of providing this service. Then the government needs to understand what's in it for us as the government. How do we make the probate service more effective, more affordable, more readily accessible by members of the public? They themselves, the government needs to sit down and devise means to make probate service easily and readily available to the public. That's on one side. Then, of course, we have probate staff themselves, because we need to consider that the people that represent the government and carry out this service on behalf of the government, they are a separate entity from the government. The probate staff also, need to understand what is the need for them. What do I need to do? If I do my work well, will I be rewarded? So all these things are things that need to be considered for us to make the probate business more viable for everybody. Apart from probate staff, we also have the applicants, who are the service users, that the people that try to access letters of administration, grants of probate. I mean, most of the time you go to the registry, you just hear people complaining about the fact that it's so difficult, or even the length of time it takes for them to access a simple document, which is a letter of administration or grant of probate. Why does it take so long? Why is there so much difficulty attached to being able to access these documents? So the applicants themselves are also stakeholders, and which is why the government needs to have a rethink and sit down and devise ways of making the service more easy to access by members of the public. And of course, we have other stakeholders like the probate consultants, we lawyers, that go on behalf of applicants to help them carry about their probate businesses. So what is the need for us as lawyers? Of course, some people will say, oh, are you not charging, your professional fee for this? But that professional fee, if you charge a nominal sum, for example, and you anticipate that it will take me 3 or 4 months to get a letter of administration, and then it ends up taking you 1 year, you are the losing end. Because at the end of the day, something that should have taken you 3 months is now taking you 1 year because of the inefficiencies or unavailability of certain things at the probate registry. So we lawyers or probate consultants, we are also stakeholders in this business. And then let's not forget the other organizations such as the banks, the registrar of companies, SEC sometimes, the stock exchange, and the land registry. So, of course, if somebody has a property that they are declaring, after you obtain your grant of probate, don't forget that you have to go to the land registry to register the new interest in the property at the registrar of titles office. So all these people are stakeholders. They need to have a rethink of how probate business is done on their individual sides, and also be able to come together to discuss probate business, because probate business is big business. It generates a lot of income for the government. Some people say, oh, dead people's money is free money. And it's very true, because the person that has worked for the money, I mean, God rest their souls, they've gone. So it's now for their beneficiaries to access this free money. The government also takes their share, because after all, it's nobody's money. It belongs to the man that has died, and then the beneficiaries want to access it. Even if they tell them to go and pay 10% of that money, they don't mind, they are ready to pay, because it's not money that they worked for. I mean, sorry to say, well, let's just be very open and honest with ourselves. So there is a lot of money in probate business, and the government has to know. I mean, the government realizes this, but the government has to pay close attention to make sure that all the stakeholders are considered in the delivery of this service, because the government has the monopoly of providing us with letters of administration, grants of probate. The state has the monopoly, but they should go about it in a way that doesn't make life difficult for the applicants and the lawyers or the consultants that represent them. Then also, the banks and the registrars, after you have obtained your grant of probate and your letter of administration, you've gone through that sweat to get it. You're now going to the bank. Oh, please, oh, we want to access so amount of money in so person's account. And then the bank will now says, oh, you need to give us this. You go to the land registry, you tell them that, oh, we want to register our interest in this property as the new owners. We are the beneficiaries of this property. We want to register our interest. Please register. Then the land registry will now say, okay, go and bring this, you have to pay this. Go and bring the income tax clearance of two of the administrators to the estate. All this makes things more difficult for people. So with respect to this, the proposal is that the government needs to sit down to devise ways of making things easier for people to access letters of administration and grants of probate. And the first step to this is by going fully digitalized. We cannot afford to miss out on the opportunities that have been created by the COVID-19 pandemic and even NSAS to go about the digitalization of the courts as a whole, and then the probate registry as well. Look at what happened in Lagos State, that the courts, I mean, the Lagos State High Court was burnt down. The probate registry was not spared. Till now, they are still grappling to rearrange the files and, you know, open to members of the public. For now, all activities at the probate registry in Lagos have been suspended. If we had a digitalized system, maybe this would have been minimized, maybe. You know, so we need to pay close attention to digitalization going forward.
So you are in favor of full digitalization and not a hybrid version that we're currently experiencing?
Otita, we cannot afford it. We cannot avoid it at this point. We can't. It is now a necessity. It's not a luxury. It's not an option. It is something that has to be done.
Yes, I agree. We all agree on this. But again, I think government too is constrained by costs and other bureaucratic bottlenecks. Yeah, so moving on.
If you talk about costs, let me just quickly say that if you want to know, the probate registry in Lagos State is #3 on the highest parastatals that generate income for the government. So if we have probate as #3, what I mean, the cost should not be a deterrent for the government. In fact, it should encourage the government to want to do more so that they can generate more revenue, if anything.
Yes, I agree. And again, this is an opportunity for all the other states, because even in Lagos, those who died outside Lagos, because their relatives are in Lagos, oftentimes access the probate registry in Lagos instead of returning to the state where the disease passed on.
Yeah.
So again, it's an opportunity for everyone across Nigeria. Yes, but we may need to open the Q&A session and then move question 5, which is what governments and probate registry may do to merge it with the final thoughts. So now, dear participants, attendees, you can raise your hand and we can allow you to speak, or you use the chat room for your questions. And if there are no questions, I have questions as well. So you may use the chat room or raise your hand and we'll allow you to speak. Thank you.
Okay, I think I can see a question here for me. Okay, yeah. Do you want me to read it out?
No, please, what did you say?
I said there's a question here for me in the Q&A box.
Okay, please read it out.
The question says, what is the process of obtaining letter of administration where pension fund is the asset of the deceased person? Do you pay estate fee where pension fund is concerned? So yes, in respect of pension fund, ordinarily, because of the act and also the intricacies involved in pension, the person that has died that has filled the form, the pension fund administrators, they have all the information. Ordinarily, you shouldn't apply for letters of administration. But because of the prevalence in fraud and fraudulent activities, the pension fund custodians and administrators will ask you to present letters of administration to be sure that they are dealing with the right people. So yes, you need to apply for letters of administration to be able to access a deceased person's pension fund. But you don't need to pay tax on the pension funds. You only pay a small administrative fee for the preparation of the letter of administration. It's not taxable by virtue of the provisions of the Pensions Administration Act. So I hope that answers your question.
Yeah, okay, we'll be hopeful. So someone is asking whether materials will be shared. Yes. So, and again, this session is being recorded and it will be available across SRJ's social media handles, and we'll mail it to you as well. So now, Your Honor, so mine is a comment. We acknowledge that even the judiciary is still struggling for independence. So the judiciary is here to gain its independence, even though it is constitutionally provided. Yes, but again, would you think, this is something you are at liberty to comment on, would you think that we can look forward to a probate registry in future that may have some sense of autonomy? Hopefully by then the judiciary would have gained its independence. So would you think that we can look forward to a probate registry in future that we have a certain sense of autonomy to operate and then determine the work tools that it needs to operate more effectively? So what I mean by work tools is, if they're going to engage a vendor to digitalize its services, they can do that without going cap in hand. So the registrar can do that without going cap in hand, begging the judge.
Well, anything is possible, so to say, but you remember that the law provides that the High Court rules committee will have to be the ones to review rules guiding, for instance, the probate registry. But I don't think it's a bad thing to hope for if the probate registry at some point in the future is independent or they gain their autonomy, because that will also help strengthen and facilitate applications before the probate, not a question of always waiting for some approval before something is done, and minor issues that probably will crop up. It will be easy for one to make a quick determination as to how to settle issues, you know. So I don't think it would be a bad thing if we have that in the future. Yes.
Okay, thank you. Thank you. So again, from my own, this is my personal opinion, I think again that we may have more actions, if I may use that word, from key stakeholders who are more committed to helping governments improve on services. So the probate registry more specifically, improve on service delivery. Why I'm saying this is that even outside Nigeria, judiciary attained independence by way of struggle. So it was not something granted to them on a platter. So again, we may have more legal practitioners who are interested in getting the judiciary to engage stakeholders more often. And then again, the registrars across the states be more willing and committed to listen to feedback from key stakeholders, so that we can enjoy the services we look forward to enjoying.
Absolutely.
Now, would you want to make a comment, Adesola?
Oh, I agree with you. I agree with you.
Okay, thank you. So finally, well, finally, but not in finality. So first, Adetola, what do you think governments and probate registries may do? So this is something that we hope that perhaps someone may stumble on and key into it.
Okay, so
thank you.
I would like to use a particular example. There's a law that is called the Small Estates Exemption Law, which exempts small estates. That means estates that are worth less than 100,000 naira, which exempts them from going through the whole letter of administration application from beginning to the end. So if you know that a deceased person that you're applying on behalf of has less than 100,000 naira in the account, and that's all he has, you don't have to go through the publication stage, pay 10% of that money, and all of that. So all you have to do is apply under this law, and then the letters of administration will be issued after you pay a nominal fee of maybe 500,000 or 500 naira or 1,000 naira. So I'm using this example so that we know that the value of 100,000 naira is so little now. Why can't we increase the value, the maximum value of that law to maybe 500,000 or 1 million naira? So that if somebody's assets or somebody's estate is not worth is worth less than 1 million naira, they don't have to go through the entire procedure of applying for letters of administration from beginning to the end, which takes maybe a minimum of 3 to 6 months in Lagos State. Why can't we just give them a letter, maybe the probate registry, give them a letter, let them take it to the bank and let the bank release the money to the administrators, instead of them to have to wait and then do publication and then do minutes and order before they get letters of administration. I mean, that's just one of many things that is coming to my head as we speak. The government should look at, incentives like that to encourage people to come forward and make it seamless or make it easier for them to be able to access the assets of deceased persons. So apart from that, of course, we know that we cannot run away from digitalization. we need to go. I don't want to sound like a broken record, but it is a truth that we cannot avoid now, especially with all that has happened. The registries need to be digitalized, not only in Lagos, even outside of Lagos. There are situations where people have applied for letters of administration in Lagos State, in Ikeja, and then in respect of the same estate, somebody comes and applies in Lagos State, in Iboshere, in respect of the same estates, yes. If we had digitalization, all they need to do is just search to ensure that multiple applications in respect of the same estates, they don't come forward. So these are things that the government needs to do, or the state needs to do, to help the process get better. I think there's a question from Mr. or Mrs. Adeyonju that we are missing. He's saying, what template is used in determining payable assessment of diseased residual estates in Lagos State? So I guess that question is directed to me. So what is residual estates? Residual estates is maybe the deceased person wrote a will and the property is not listed in the will, it will be considered to be residual estates. So how does the registry, take charge of such estates? After you've applied for grant of probate in respect of assets that have been listed, or if at the point of application you realize that the deceased person did not write it in his will, but he owned these assets, you can also include it in your application. But when it is not included, that means you have to come back and apply for a certificate of additional assets. And it's the same procedure, except that there is no publication and it's shorter, but it's the same amount of money that you pay in respect of grant of probate or letter of administration that you also pay for certificate of additional assets, except for shares where it is 1 naira instead of 2 naira. In Lagos State, I don't really know the situation in other states. So that's to Mr. or Mrs. Adeyonju.
Okay, thank you. So before we turn to you, Your Honor, may I make a comment which you may take into account in your response? Now, I wouldn't know if there's anything that prevents the probate registry in Lagos or in Anambra states to conduct e-interview. So because essentially the interview is usually after the documents have been approved, either preliminary or final approval. And then the sureties are invited to an interview with the designated officer. So again, is there anything that prevents e-interview? So for instance, we're all in different locations. So Your Honor is in Anambra, and we are in our offices in Lagos. And then the attendees are joining across states in Nigeria. So can the registry begin to adopt e-interview in certain circumstances? Your Honor, please, you may react to the question and then take this into account. Thank you.
Sorry, please, I didn't get the question. Sorry.
Okay, so the first question is, what can government, can you hear me now?
Yes, I can hear you now.
Okay, thank you. So the first question is, what may governments and probate registries do to enhance innovative services and then improve on the user-friendly settings? And then again, added to that is, can probate registries begin to adopt electronic interview for the sureties?
Okay.
Yes, I mean seamlessly.
Well, if there are useful policies that will make the procedure for obtaining letters of administration and grants of probate less stressful and more realistic, then it should be embraced. For instance, I'll give you an instance, like in Anambra State, Section 58 of the Administration and Succession of Estates of Deceased Laws of Anambra State, where the Administrator General is empowered to administer small estates without the formality of common probate, forms and all that. Here, our small estate is categorized not exceeding 600 naira. I mean, tell me, what estate can be placed at 600 naira in our time now? Now, this fee appears ridiculous. Okay, apart from trying to raise revenue, one should look at the reality on ground. Now, considering the fact that this provision was made many years ago, in the present age, it's ridiculous, and the qualification of an estate to be addressed as small is 600 naira. Now, legislative intervention is needed to raise the value of such estates. Like in Lagos State, I'm aware that the fee or value placed for small estates is pegged at 100,000 naira. And that in Bayelsa State, a small estate is regarded as an estate where a deceased person left money in the bank, not exceeding 2 million naira, though it excludes real property. There's need for it to be reviewed, especially in Anambra State. I suggest that the higher the value of the property, maybe the lesser the estate fee to be charged. For instance, if maybe 3% charge for maybe placed in valuing large estates so that it can accommodate everybody, And then, like, I also suggest that rather than allow small estates go through the rigors of obtaining, just like Mr. Yaro said, rather than obtaining letters of administration, they may simply apply with proof and be issued with a certificate, to ease business. I mean, that's what this is all about. And for instance, if, like she said, if someone left a sum of 100,000 naira, and then you can think about the rigors, all the stress the beneficiary is going to go through just to accept that. And then by the time probate fee is charged, what's left for the beneficiary? So, and not only that, the 10% charge on such amount of money does not appear realistic to me. In Ghana, rates charged on large estates is about 3%. And we all know that today there's no estate that can be calculated at 600 naira. So there's need for a review in that law. And then coming to the side where interviewing shorties electronically, I would want to refer to our rules where it states that all shorties must be resident within jurisdiction. So how do we now determine where those shorties are as at the time of the interview? It's something we should consider, as there's need to review these rules. So it's also going to be something that will affect the process, because if they are not resident within jurisdiction, they are not competent to act as shorties for the applicants, for the supposed applicants. So I welcome that idea though, but I believe there will be a lot of they'll have to do a lot of modifications to enable shorties be interviewed electronically. But then, how do they get to sign? Do we forward the forms to them? They sign, they scan, and return it. Well, these are things that need to come into perspective one way or the other. Thank you.
Okay. Thank you so much. Now, Adetola, there's a question in the chat. I wouldn't know if I've responded to it. What happens to a missing receipt in respect of a will where the testator wants to change, so to change the will but cannot find the receipts? So perhaps the payment receipt.
I thought the question, I was going to bring it to your attention. So it's simple. If you can't find the receipt, you can depose to an affidavit of loss. That in so year you lodge the will and you cannot find the receipt, you want to withdraw your will and maybe lodge a fresh one. Once the names and the details of the applicants are stated on the affidavit and then the letter of withdrawal, I don't see it becoming an issue. Just depose to an affidavit of loss that you can't find the original receipt.
Yes. So with this, we are coming to the end of today's session. So we've been able to manage our time very, very, very well, thanks to the panelists. And finally, may I, in no particular order, acknowledge the law firm of SPA Ajibade for allowing her dearest Adetola to sit on this panel.
Thank you.
And thank you, Adetola, for agreeing to come.
Thank you. Thank you for having me.
And in thanking your honor, I will acknowledge the immense help of Professor Peter Umadi, the immediate past Chief Justice, the Chief Judge of Anambra State Judiciary, who has helped us in a very fatherly way. And thank you, Your Honor, and thank you, Anambra State Judiciary, again, for allowing you to come. And thank you for agreeing to come. We are very grateful to the attendees who made time to attend this session. Our appeal is that we all continue to find ways to engage, particularly the probate registry and the state judiciary, and then help them, we are not being antagonistic, but in a way to help deepen innovative services and ensure more user-friendly services, which is more beneficial to all stakeholders. And indeed, on this, we hope that we will not be asking for too much if we look forward to, again, perhaps in future, bringing any of the panelists to our future sessions. Once again, yes, thank you so much. We are very grateful. So with this, we come to the end of today's session. Thank you.